Good afternoon, everybody. My name is Charles Raether, managing partner here at AmLaw Group, where we focus on people such as yourselves making a transition temporarily or permanently to the U.S. If you haven't already done so, please consider signing up, subscribing to our channel to regularly receive our content on all aspects of immigrating, transitioning to the U.S. Whether you're looking at an EB-5, E-2, or a talent visa, or something in between, you're sure to get some valuable content if you become a subscriber to our channel. And so the topic of today is actually how do attorneys go about evaluating talent-based visas? We generally consider talent-based visas the following: EB-1A, NIW, and O1. And here's the thing that I would say: there's kind of two camps of lawyers, two schools of thought as to how attorneys approach these talent-based visas. One I would say is a good approach, and the other one is not so good. What am I referring to? In particular, I've noticed a lot of times when attorneys talk to clients, they say whatever they think the client wants to hear. And in many cases, if you're talking about talent-based visas, attorneys are sometimes unscrupulous in terms of giving honest advice. They might tell the client, hey, you've got a great background, you've got great expertise and great evidence, and everything looks great, and you're going to have a great case. But once they start working on it, both maybe the attorney and the client, to their surprise, learn that things aren't so great as they thought. It's tougher going. It's more difficult to put together the needed criteria and evidence in order to make a strong case. So that's one school of thought. In terms of attorneys, they tell the clients everything they want to hear. They reassure them everything's going to be great, when in fact the reality might be a little bit different. We take a different approach, and sometimes clients don't like that, but we are hard realists. We will tell clients directly, specifically, where we see the weak spots, where we see the strong spots, and how good of a case we think at the end of the day we can create for clients. Now, even our initial assessment can be wrong. It might be too pessimistic or too optimistic. When you're first meeting with a client initially, it's difficult to give a very clear estimate of what their case will be, because a lot of times we don't have all of the needed information from the client at the time of that first intake interview. However, we generally have a pretty good understanding of what the client has, what they can probably collect, and what's the likelihood that they could collect what we think they need in order to have a strong case. And based on that, we give clients, our direct, unvarnished feedback. So how do we generally do that? If you're looking at the talent visas, I would probably distinguish them between the EB-1A and NIW. O1 is very similar to an EB-1A, a little bit easier, so we'll put the O1 in the category. With the EB-1A, the focus is more on the person. What awards, recognition, distinctions did he or she receive that would place that person in the top percentile of experts or specialists in that field? Whereas with the NIW, you focus more on the actual activity. Yes, the person himself is important, what kind of experience he has, what kind of work he does, and what kind of credentials he has. But with an NIW, what's much more important is what's in it for America. Basically, what is that work that person does that makes him or her so special and valuable to the U.S.? Now, there's different ways of evaluating this, and even among experienced attorneys, some people might, have a more optimistic assessment of somebody's role and activity than somebody else. But again, I think generally experienced attorneys are able to equally weed out and clarify the strong cases from the weaker ones. What makes a strong case, though, for this? Whether you're looking at an NIW or EB-1A, I think there's certain features that are common in all of these that are critical in making a strong case. First of all, they look at overall consistency, meaning consistency of activity over a sustained period. That's particularly true for the EB-1A, that we have to show that this person is an expert over a sustained period. If, I'm making this up, somehow you became an Olympic champion just in the last 3 months, and before that you didn't have a lot of a track record, and since then you haven't done much. That's not a long enough time period to show that you've had this sustained level of acclaim, this sustained level of high performance over a long enough period of time. How much time is necessary? Good question, depends on a lot of factors, but I think it's safe to say you probably got to look at least 2 years or longer. 1 year might be enough, depending on the strength of the other evidence that the client has, but I would say at a minimum, you're looking at 2 years, ideally probably 3 years or longer, to have a sustained period of time of achievement that would qualify for these visas. What else is important? Third-party validation. EB-1A, it's very important, and usually third-party validation is provided by recommendation letters from experienced experts. Not from bureaucrats, not from politicians, not from somebody at the local mayor's office in the city where you live, but from other recognized experts in the field. It's also important for NIW to have third-party validation. Maybe not as critical, but it still is nonetheless quite important, because even if we can explain why our client is such a great and talented individual, I'm making this up, you make sweaters for dogs, and you're the best sweater maker for dogs, in the country, or if we can't show that this fills an important niche in the US, then it probably doesn't matter a lot. But if we can provide third-party validation letters, maybe interest of cooperation, working together, or past experience of working together that says, hey, yes, this guy does dog sweaters, but believe me, these are the best dog sweaters ever, and here's why that's important for America. If we can get information and written statements to that extent, that makes both an EB-5 and an NIW case much, much stronger. Another important factor for both of these types of talent visas is the impact that that person has made. In the context of an EB-1A, they tend to look more at the impact in the industry or sector that you're working in. Are other people copying what you do? Are other people emulating? Are other people taking what you've done and building upon it to create even more greater innovations or move that sector forward? You don't have to necessarily show the impact so far of your work for an NIW, but with an EB-1A, that's a little bit more of a requirement that we need to show prior to you filing that you've already had a very strong impact. So this is just a flavor of some of the three more important criteria that are used in evaluating talent visa. At least these are ones that we use. And you should understand as well, the vast majority of our clients for these visas do not have a full set of properly prepared evidence for their case when they come to us. They often have a good start, they have an excellent background, they have some excellent awards and other work, but oftentimes, and I would say the majority of the times, we still need to work with the client a little bit to ensure that they have a strong case and they meet the minimum criteria for one of these visas. So don't be discouraged if you might not have all of the needed criteria, but please keep in mind if you don't, you need to have some flexibility in order and ability to collect those additional pieces of data or information to make your case a successful one. If you have any questions about this or anything else related to transitioning to the US, whether with a talent-based visa or any other one, please feel free to reach out to us today, whether it's through our contact information below in the description, or you're more than welcome to go to our website, get more information about our practice and how we've been assisting clients such as yourselves for more than 15 years in making a successful transition to the United States.